Welcome to Business Law 1 class. Today, we will look at Section 4 of Unit 5, the equitable remedy of specific performance. Session objectives. By the end of this session, you should be able to explain the remedy of specific performance, state the condition for granting specific performance. Now, we are saying that a specific performance is an equitable remedy available at the discretion of the judge. So we say that a remedy is an equitable remedy. It means that remedy will be granted if the judge is satisfied. It is at the discretion of the judge to decide to give it to you or to decline. And here it is an order compelling the one who has been the contract to perform his or her contractual obligation. So when you enter into a contract with another person and the person fails to perform his or her side of the contract, and you want the person to perform what he or she stated that he's going to perform, then your remedy that you are seeking for is specific performance. So the person will now perform his contractual obligation as stated under the contract. The court must consider certain factors before it will grant the order of specific performance. The court must consider whether damages will be adequate remedy. What this means is that if the court thinks that granting you damages will be okay, will be enough, then the court will decline the order of specific performance. Where there is mutuality, that the defendant can also be granted same remedy. The principle of mutuality simply means that if the order can be granted against the innocent, the one who has breached the contract, then the same remedy should be possible for the court to grant against the innocent party, assuming that the innocent party breached the contract. Also, the court will consider whether or not it will be possible for the obligation to be performed. So if the obligation cannot be performed, even when they order for specific performance, then the court will decline. The court must also ensure that or satisfy itself that the plaintiff was not indolent or he or she has not delayed. Now, if the plaintiff was indolent or delayed, the court will refuse the order of specific performance. Also, the court must consider whether or not in giving the order, the court must still supervise the performance of the contractual obligation. If they will have to supervise, then the court will decline the order of specific performance. Now we are saying that specific performance will not be available if damage may be adequate remedy. It will not be granted. If it will cause undue hardship, it will not be granted. If supervision is required by the court, it will not be granted. Now you should also note that where an order of specific performance would be possible against one party to a contract, but not the other party, then it will not be granted. This on the grounds of principle of mutuality. Where the party seeking the order has acted unfairly or unconscionably, then you cannot be entitled to the order of specific performance. Now, the reason is that he who comes to equity must come with clean hand. Before you ask for specific performance, you should make sure that you have performed your side of the contract, you have performed your obligation and the contract. Now, you should also understand that while the order is not sought promptly, the claimant will be barred by the maxim delay defeats equity, and equity assist the vigilant, not the indolent. That is the case of Smith v. Clay. What this means is that the court will consider whether or not the plaintiff, who is the claimant, acted within reasonable time without delay. If the plaintiff delayed, then equity will not come to his or her aid. Now, you should note few points under specific performance. We are saying that time can be essence in the original contract, but the parties may have the right to waive it. It means that the parties may indicate that time is not of essence, so you can perform the contract within a reasonable time. However, if it is not indicated that whether the time is of essence or not, the court will look at the conduct of the parties to determine whether or not time is of essence. The conduct of the parties to determine whether time is of essence, so that the court will be able to determine whether the innocent party acted within a reasonable time. So the principle of mutuality is also here. It's a key principle under an order of specific performance. Now, the defendant cannot rely on his own fault to resist the order. If you are at fault, you cannot resist the order on grounds that you made a mistake. Your default will not even be a reason for the court to refuse the order. So the defendant, if he or she makes mistake, the court will still go ahead to grant the order of specific performance. If it is the fault of the plaintiff, then that the plaintiff has failed to perform his set of the obligation, then he has no right to ask the court for specific performance. The court will deny such claim. We should also understand that part payment or performance by the plaintiff may suffice to entitle one to an order of specific performance. What this provision means is that, look, if you make part payment or if you perform part of your duty or obligation, it gives you the right to bring an action for specific performance if the other party fails to perform his side of the contract. In a nutshell, we have described the remedies of specific performance as well as the conditions under which specific performance will be granted. Thank you and have a nice day.